Hi, everybody, and welcome to Raw Law. My name is Arkady Frekhtman. I'm a personal injury trial attorney here in New York City, and welcome, everyone. So let's get into it. This is the show where we read your comments and we answer your questions. So I'm happy to do it, and let's get into it. Let's see. Norma says, good evening. Hi, how are you? Great to see you. And let me go back to, okay, JRM says, cool. Devin, let me change it to live chat so I see all the chats in order. Okay. Oh, Devin says, Dad was diagnosed with post-traumatic headaches and post-concussion syndrome caused by a semi-wreck, 100% liable in Washington State. Any idea how something like that is valued? 1 million in policies. He's currently waiting on his TBI testing also, and does have mild whiplash and sprains to his right shoulder. Yeah, so I mean that could be valued at a very high amount, but the important thing to remember is that you have to have a trial lawyer, somebody who's going to prepare the case properly. So it's critical, right? Because somebody actually texted me this morning, also from Washington State, and they were saying they have this lawyer, and the statute of limitations is only like a few weeks away, so the case could be dismissed. And he's also had 2 surgeries, right? This other person, and they haven't even filed a lawsuit, and he's hoping they're going to settle as a claim. Remember, as a claim is like anyone could do it. You just pick up the phone, you call the insurance company, and it's whatever they give you. But they're not going to give you real money unless you file a lawsuit, and you also need a trial lawyer. So I looked up this client's attorney, and the attorney has like no settlements, no verdicts ever, and it just looks a little bit like a red flag. Now I don't know about this particular person, Devin, but I think that TBI, if it's real TBI, if you're doing like diffusion tensor imaging, if you're doing 3T MRIs, if you have the diagnostic testing, the neuroradiology, and you have a neurologist, if you have the proof, then it could easily be worth way more than the million policy, right? Because it's a real TBI. A TBI has tremendous value because that's your memory, your emotions, your executive functioning. It's like everything. It's your brain. Without that, you just, you can't live without that. That's everything. So yeah, that could be worth way more than just $1 million, especially these days, right? So $1 million isn't really that much money anymore. So, so yeah, people are getting much bigger. Like there was a lawyer who I watched some of his presentations. He was actually on the listserv, and he was handling a TBI for a child. And I think during the trial, he just didn't pick the jury. And after that, it settled for like 125 million. So that just gives you an example. Like if somebody really knows what they're doing, they can get crazy numbers. It doesn't have to be limited to just $1 million. But yeah, I think if that's the policy, if there's no more and there's no excess, there's no umbrella, there's nothing else, you could probably get that. And if you need somebody in Washington who's like a real trial lawyer, just text me. I know some of the best trial lawyers in Washington. I was actually out in Washington last year around, I think, end of April. And I worked with some of the trial lawyers out there. Yeah, there's some excellent trial lawyers out there. And Marquita says, trip and fall in Publix, aisle obstruction, cerebral palsy, sacroiliac joint fusion last week. Any question I should ask my surgeon. Lawyer isn't doing anything for me. She's saying I did everything alone. Had to gather the medical records and the bills, liability evidence, wrote a 50-page demand letter. Why isn't my lawyer motivated to push forward? I've made it easy for her. Oh yeah, I remember this lady. I think we talked, right? I mean, I think I texted with you, and then also I was answering your questions. I think I answered your questions actually on the live, on the other one, right, where we did the verdicts. I actually tried to research the verdicts in your state, so that's why we didn't have the actual phone consultation. But you know what? Let's do that. Just text me again, or I might have your number I should have your number in my phone. Let's do a confidential consultation, and I'll speak with you. And then look, if your lawyer really isn't doing anything, then I could see who's the best trial lawyer in your area and maybe recommend someone for you. I don't know. I mean, I can't say why a lawyer is not doing something, right? I don't know. It could be that they're busy. It could be that they're lazy. It could be that they just don't really want to work. They want to make an easy buck. There's so many possibilities. I can't really speak for what someone else does or doesn't do. All I could do is, I can help you in any way I can. I'm happy to help. But I think you have a good case because, you have a trip and fall. The public should have enough insurance. You have sacroiliac joint fusion as a serious surgery, and you already have a disability, so they should be more careful, not less careful, for someone like you. And so I think you have a good case. I think is this the one in Alabama? I think it's Alabama, right? But yeah, I think it's a good case. I could actually research. I could go to the jury verdict search, and I could check like Alabama cases, with, let's say, back fusion. I think there weren't too many with sacroiliac joint fusion, but we could, similar injuries, or we could check trip and falls, and we could see what the numbers are and who's getting like $1 million results. And then you could go to one of those lawyers who've already won the $1 million results, right? So who's more likely to get it? Someone who's not even calling you back, not doing anything, or someone who's already accomplished, getting $1 million verdicts over and over again. So I think it's in your best interest to get someone like that. And I'm happy to help, facilitate that. Okay, and then Robin says, have you ever had a case where the insurance company gives you an offer, then takes it back or off the board? I mean, it's unlikely. They usually don't do that. Once they give you an offer, the offer is usually there. They sometimes say that, oh, if you don't take it now, we're going to take it off the table. But usually what happens is they just increase the offer. So whatever you have now, it's just going to be higher later. As long as, there's not like a major issue. Like one time I did have a case like that where a guy told me that he tripped and fell on the sidewalk and he had an offer like $95,000. This is like a long time ago. This is like 15 years ago. And then in his medical records, it says I tripped and fell in the shower while the shower was running. So like once they saw that, it settled, but it didn't settle for like $95,000. It settled for less, maybe like 20 or 30. I don't remember, but it was because it was a big problem. But if you don't have any like horrible problems like that, then I think it should be fine. It'll just go up, And Miguel says, after all surgery and all discovery. After all surgery and all discovery. I'm not sure what that refers to. Oh, maybe I scrolled down too much. Sorry. Let's see. Oh, here we go. Yeah, Miguel says, Arkady, good afternoon. A case that does not have a court date and a letter is sent to close the case. Is it easier to close it even for less money, 70 out of 100%, after all surgeries and all discovery? So you're talking about a case where you don't have a trial date and you're trying to send it through a letter to try to settle it, like a settlement opportunity, or what they call a demand letter, a settlement letter. Yeah, you could do that. You could try that. And you're saying, is it easier to close it if you're willing to take less, like 70% of the value? I mean, yeah, of course. It's hard for me to say, you just send a letter and then they're going to make you an offer. If you're happy with the amount they offer you, you could take it. If they're not offering you enough, just say no, thank you, and just push it towards trial. That's your threat, right? If they're not giving you enough, then you're on the trial calendar if all discovery is done, and you're going to get the trial date. And that's what you use as your leverage to get them to pay. You say, hey, pay me $1 million now. You have 30 days. If you don't, then I'm going to go to trial. But guess what? At trial, I'm not going to be asking for the same $1 million anymore. It's not the same. It's going to be like $3 million. So pay me the $1 million now or pay me $3 million later, So that's how you get them to pay. And Preacher says, hello, hope things are going well for you and your family and team. Oh, thank you so much. Yeah, everything's going pretty good. And Lakeisha Jackson says, hi, how are you? And let me see. Renee says, hi, Arkady. I'm glad I caught the beginning of your live. I'm here. I enjoy all the good information you give out. I'm here to listen. Oh, thank you so much. I really appreciate that. Yeah, let me know if you have any questions too. I'm happy to answer. And Lakeisha says, I have to get injections and pain management. Yeah, I mean, pain management could be, those cases could be very valuable. It depends on the type of injection, right? Epidural steroid injections could be even 100,000 or more. If there's a percutaneous discectomy, which is a type of surgery with a striker decompressor where the straw kind of like removes the injury from the disc, That could be even higher. Those could be even, 500,000, 300,000, much bigger cases. Digital Audit says, Arkady, a lawyer told me if the defense admits full liability, then the prosecution is not allowed to mention the DUI driver. I'm confused. The entire claim is based on being injured by a drunk driver. Thank you very much. Well, I think what they mean is, right, the fact that the driver is drunk, if that goes to liability, meaning the question of who is at fault, and if they already admit, yes, we are at fault, then, you can't really mention. It depends on the judge, but the judge might say, well, you can't mention that he was drunk because fault is admitted. The trial becomes a damages only trial. So the only thing you could really talk about is your injury and your damage, whether it's lost wages, future medical costs, your pain and suffering, your loss of enjoyment of life, those kind of things. But I would try to put it in there. I mean, the worst thing they can do is say objection, right? Like when you're testifying, let's say your lawyer could ask you, okay, how did the crash happen? Where were you feeling pain? And you could sneak it in there. Yeah, I was feeling pain because this drunk driver slammed into me. What are they going to say? Objection. Okay, sustained, but they heard it. But I think you could actually get that in another way. You could actually, if the lawyer's smart, what the lawyer would do is he would prepare you to talk about the fact that, the other driver was drunk and the other driver crashed into you, that gave you trauma. That gave you, let's say, like something like post-traumatic stress disorder, or made you emotional, made you worried, made you upset. And then that goes to your damages, you see? So there are ways to get around it. But also, you don't have to accept it, right? Just because they admit liability, you don't have to accept the admission. You could say, I don't want you to admit liability. I want to try liability and damages because it's better for you, right? You're not going to lose liability if the guy's drunk. So why? So they want to admit liability. Guess why? Because they want to use that as an advantage. It's like a card game, right? They want to, give up like a bad card, which is the liability, and say, oh, we admit liability, and then they want to use that to pay you less money, right? Because now they have they're kind of like showing face and saying like, look at us, we admitted liability, we took some responsibility, we're so good, right? And then they're going to think, oh, the jury's going to feel sorry for them. They admitted liability, they're doing the right thing, so then they should pay less. But that's just a trick that they do. So you have to be careful with that. So some lawyers don't you don't have to stipulate to that. You can say, no, I want to try liability, and then you can get everything in, right? So it's up to the lawyer, but there are ways around that. And like I had that in my case too, when I had the trial with the girl who had the CRPS. They admitted liability, and we accepted their admission because we had a trip and fall case, and it was like in the grass, and there was like this metal sticking out, which we probably could have won anyway, but they admitted liability. We said fine, but we really wanted to get out the fact that this owner of this property where she got hurt, that this owner knew, and he had the chance, like the equipment was there to fix it, and he was just so cheap that he didn't want to pay like $300, whatever the rental fee was for the equipment to fix it. So then the company came and repossessed the equipment and took it back. And that's why it was like a jagged edge of a pipe that he never finished fixing because he didn't want to pay for the rental equipment. And so I kind of got that out. I said, what other factors were there that, and she's talking about how the fact that when she found that out, that the guy was so cheap that, kind of added to her emotional distress. And so the jury hears it. I mean, whether they say objection sustained, objection overruled, I mean, it doesn't really, the jury hears it. So, but yeah, you definitely want to get that out, I think. That's a good thing to get out about him being drunk. And Zafraz says, the insurance hired an investigator to video me. They caught me lifting 2 grocery bags, and I have a second deposition next week. At my first deposition, I told them I can't lift heavy. What will happen? Well, you just have to explain it, that you were lifting grocery bags. You say, look, they weren't heavy, they were light, and I could lift. I can't lift anything heavy, but I can lift grocery bags. Since they have you on video doing it, you have to admit it, right? You can't say, it wasn't me, unless it wasn't you. They tried to video one of my clients. It's so funny. They videoed this guy, and it wasn't our client. It was just some other guy, because I guess he has a big family, like a lot of uncles or cousins. And so it wasn't him. So at the deposition, we actually asked them, we said, do you think you videotaped the plaintiff? And the guy goes, yes, so of course. I'm like, okay, no further questions, because it's going to be funny if they ever try to use it, because it's not our client. But yeah, if they have you and you've seen the video and it's actually you, I guess you just have to be honest. But what can you do? You have to be honest. So just say, look, I meant that I couldn't lift anything heavy, and this was like a light grocery bag. Maybe it was just some, what's light? I don't know, just some like one apple or some eggs. Nothing too heavy. It wasn't like, I mean, because look, if they get you and on something that's like significant, then what's going to happen is, the value of your case will just go down. It'll still be worth something. Like they got my client like many years ago, also like 12 years ago. I just remember this. We had this lady, and she also had like a surgery on her back, and she goes, I can't lift anything heavy. And then they had her in Costco, and she was lifting the 5-gallon waters, like, lifting them up like one in each hand, putting them in the back of her station wagon. So what could we do with that? Obviously that's, if she could do that, then that's not so good. So that case settled. She still got like, I think 300 or 350,000, but it wasn't as much as like if she hadn't done that, maybe she would have gotten like 850 or over $1 million, So it's not good, but you just have to come clean. You have to be honest. What can you do? And Marquita says, yes, Alabama. Yeah, just text me again. Maybe we could chat tomorrow or Thursday. I'm happy to help with that. And let's see here. Come along with Uncle Joe says, good evening. Hi, how are you? Lakeisha says, neck and back injury. I have to get injections from a ceiling collapse at a hospital in New York. Okay, yeah. Yeah, that should be a good case. I mean, a ceiling collapse is always a good case with neck and back injuries with, this kind of injections. That could be substantial. And come along with Uncle Joe says, is a lawyer that used to be a lawyer for the insurance company a good lawyer to have on your side, even if he doesn't have much experience of being on the injured person's side? It could be. I mean, what I found is those kind of lawyers, they're not really that great, because if they were working for the insurance company for like a long time, then they have that insurance company mindset, which isn't really the best for you, right? Because what you really need is somebody who's like more of a diehard plaintiffs, like a true believer, right? For plaintiffs, for injury victims like me, right? Or people like who are kind of like that, who never worked for the insurance company. Because once you work for the insurance company, you're kind of like, you're indoctrinated with their thinking, their mindset, and it's completely different. It's almost like learning a different language, right? If one person speaks, let's say, Chinese, but the other person speaks Italian, they can't really communicate. So it just depends on what you want. Like, well, what I found is the people that do work for the insurance company and who've worked for insurance defense, they're usually pretty good at, the paperwork, good things like that. Sometimes people could work there and then switch over and then be good trial lawyers for the plaintiff too. But usually, I like more of the diehard, like, true believers, the people that are passionate for the plaintiff and never worked for the insurance company. And Marquita says, I had a subsequent fall after my initial fall in Publix due to the SI joint dysfunction proven by doctors. Will that help or hurt my claim? Well, if it was because of the injury you had, what you do is all that goes to the original injury, right? Because like you had the fall, and then you needed the SI joint surgery. And then if you had another fall because of the SI joint surgery or injury or weakness, and if that other fall had additional injuries, you don't have to sue for the second fall. That's just an injury, right? It's called natural sequelae. It flows from the original incident. So you just sue, all the injuries just go to the original incident. It actually helps because you have more injuries. So yeah, that's natural sequelae. Okay, and then Bert says, how would I know if my lawyer is good? Well, I mean, just based on your own interaction, right? Do they answer your questions? Do they, you could go to their website, see what kind of results they've received. Although sometimes people put they've gotten results and it's not true. So you could text me. I'm happy to do a search and I could tell you. I have access to a few of the databases like Westlaw, Lexis, Verdict Search, things like that. But it's not just the results. It's also like the overall interaction you have with them, if you're happy with them, right? Are they, you know, it's kind of hard to, you know, there's a lot of different things, but it's basically just like how you know anyone's good, right? Any profession, like a doctor or any kind of professional. Okay, and then Zafra says the grocery bags were not heavy. Okay, that's good. Yeah, I would just come clean with it. If they weren't heavy, it doesn't matter. And Preacher said, what are some ways I could get my lawyer to push the case forward? It has been in neutral for 40 days since they received all the medical records and income tax returns, but no movement. So they received the medical records and the tax returns, but no movement. It depends on, you know, what movement you want. If you want them to send like a settlement opportunity letter, just let them know, hey, so let's send a settlement opportunity letter. And then they'll do that. If you want them to do something else, like if it's in court or you want to file a lawsuit, then, you know, hey, let's file a lawsuit. You know, maybe you could set up a meeting with them, go over to their office, set up a meeting, call them or text them or email them or, you know, do a Zoom meeting and just, you know, tell them what you want them to do, or ask them, hey, what plan do you have for my case? What's the litigation plan? What's the next step? And then they'll tell you. But yeah, definitely stay on top of them. And Nene says, good evening, Arkady. What happens at a settlement conference? Okay, yeah, so at a settlement conference, they try to settle the case. You know, basically, the judge will say, what's the offer? What's the demand? And then the plaintiff will say, let's say, I want $1 million. And the defendant will say, well, we don't have that. We have 100,000. And then they say, well, how far lower than $1 million will you go? And then how much higher than 100 will you come up? And then could we meet in the middle somewhere? Can we settle it? If not, then you get a trial date. And then you could also try settling the case privately, like at a mediation. And Brandon says, I'm from Florida. I always see you on here. That's why I was asking. Oh, I think you're talking about someone else, right? Oh, I think he's talking to one of the other people in the chat. Okay. Secreting says, after I had another surgery, the defense attorney wanted another deposition. Why? What questions are they allowed to ask? Right, because like a deposition, they ask you about damages and about liability. Now, if you had another surgery, obviously they couldn't ask you about that surgery or the way that surgery has affected your life because you hadn't had the surgery right at the first deposition. So they're just going to ask you all about that. Like, why did you have the surgery? Who told you you need the surgery? What are all the medical visits you had that led up to the surgery? What doctor did you see? Did you see the surgeon? Where was the surgery? Which hospital? Who took you to the surgery? How did you feel after the surgery? You know, what are some of the things you were able to do before the surgery that you now cannot do? What are some of the things you can still do after the surgery, but not as well as you could before? You know, things like that. How has the surgery impacted your life? So actually, it's good. It's an opportunity for you to really like show your case. And if you meet with your lawyer, or if you're able to, you know, come up with like a little outline and talk about and really explain, hey, how your life has changed after the surgery, it could make your case much bigger, right? Because if you just say, I had a surgery, it was L5S1 discectomy. Okay, what is that? Nobody knows, right? But if you explain, hey, I was my lower back, and I used to be able to do things. I used to go to the grocery shopping. I used to bend over and pick up grocery bags. Now I can't. Now someone else has to do the shopping. I used to, you know, carry a backpack. Now I can't because of the weight. I used to play sports with my kids, with my grandkids. Now I can't run. I can't throw the ball. You know, and then it really shows the impact on your life. And then you could also have what are known as before and after witnesses, which are people from your life that could talk about things you were able to do before and now things that you cannot do, or how your life has changed after. So that's very important too. That's good for other people to talk about that. Because if you're the only one as the injury victim who talks about that, then it seems like you're like a whiner and a complainer. You don't want to be a whiner. You don't want to be a complainer. You always want to be, positive. You want to have like hope. You know, you want to say like, I'm doing the best I can. But other people could talk about, people that know your life, about how the surgery has impacted you. And Secreting says New York City. Okay. So that's in New York City. Yeah, I mean, you could also text me. I'm happy to chat. And if you need questions for the deposition, like what they're going to ask, if your lawyer isn't preparing you, you could see my video. I think it's called Super Depositions. It goes into pretty good detail. I think it's about 40 minutes long. It goes through all the questions they usually ask at these depositions. And then Burnt says, also in Florida, is there any website I can check to see for my trial date? You know, there might be a public website. Like in New York, we have NYSIF, the New York State Civil Electronic Filing, and they also have other websites like ATTY LAW where you could log in and you could see what's happening. And I know in California they have that. I think in Florida they probably have that too, although I'm not, you know, I don't really practice in Florida, so I'm not sure what it is, but it might be each court or each county has their own website where you could access it. But you could ask, if you have a Florida lawyer, probably ask the lawyer, he'll probably know. And Baby Boy says, just showing support. Okay, awesome. Thank you so much. And Lakeisha says, hey, they're going to start with injections. Then I have to get a surgery where the bulging disc and herniated disc has liquid. They have to drain it and bring it back to normal. Okay, that sounds like the percutaneous discectomy where they kind of like decompress the disc so it's a perfect circle again. They get rid of the bulge or the herniation. That sounds like one of those. Yeah, so that's pretty serious. That, like, I've settled those cases even for more than $500,000, so it could be a pretty good case. And Khalif says, hi, Arkady, have you ever had cases where your client had a medial branch block? Yeah, I've had those. That's usually part of pain management, so that's just one of the procedures. I've had cases with that. Absolutely. That's usually the medial branch block. What happens is you have a lot of nerves, right, coming off your spine. I don't know if I have a sample I can show you. I might have it here. This is like kind of a sample. I don't know if this is going to show everything, but like you see how you have here, these are the nerves, but they don't stop. They keep going. And there are also smaller nerves. So if you don't see it here, but there's smaller nerves like here, and those are like the medial branch nerves, because these are the big nerves, but they're also like smaller nerves. Smaller nerves are almost like, just like on a tree, right? You have like the big branches, and then you have the little branches, and you have the little vines, and some of the smaller ones, they actually are right up on the vertebrae in some of the pictures. So that's a medial branch. That's usually they do those blocks to alleviate the pain. And RG says, Miami-Dade, Florida, cervical fusion, shoulder arthroscopic, labral debridement and repair, 1 million policy, truck crash, not huge damage, trial will be in April, still an IME going on before mediation, case worth. Yeah, I mean, look, if you're in Miami with a fusion, and plus you have other injuries, I think if it's a truck crash, it's not your fault. It should be worth close to the policy. I mean, why not the whole million or close? As long as it's been prepared properly, you have a strong trial lawyer with a strong record. I don't think it really matters that there wasn't huge damage because it's a big truck, right? Whether it's full, like if it's a tractor trailer, whether it's full or whether it's empty, it's going to be, it weighs a lot. A full tractor trailer could be like, what, 70,000 pounds? So you can get hurt from that. So yeah, that sounds like a pretty strong case. And Nene says, with 1 million policy and 2 surgeries, what's your case worth? A truck hit me while I was crossing the street with my dog. He ran a red light. Lawyer is the worst. I want to change to you. Oh, I'm sorry to hear that. Yeah. I mean, I'm sorry to hear both, that you have a bad lawyer and that you got hit by a truck. That's terrible. But I mean, if you're walking with your dog, you're a pedestrian, right? Then the truck has more of a duty to see you and to stop, right? Because unless you're like in their blind spot, but if you're in like the crosswalk, they have to really, there are codes on that. In fact, I was gonna do some videos about them. I was studying some of them. I actually have a few trucking cases too. See, there's like a whole manual here, entry-level driver training, like obtaining a CDL manual, and they have everything. And actually, you could put this kind of thing. I mean, you could read it, of course, and know all the codes, which people have to do to pass. But you could also like put it into, let's say, one of those like ChatGPT AI, and then you could ask questions and it'll answer and it'll tell you, hey, which section is being violated. So that could be powerful too. Like I actually was working on it for another case that I have, and they were saying that you know, there's something known as no zones for like these truck drivers, no zones. So it means that like it's known that they're not going to be able to see certain areas when they're high up. If it's a real tractor trailer, there are certain areas they're just not going to be able to see. And that's how pedestrians get hurt a lot of the time. So it's really simple. I mean, you don't drive when you can't see, right? It's almost like you don't close your eyes and start driving a tractor trailer that's 70,000 pounds. That's crazy. So those could be very, very good cases. But yeah, you definitely need to prep those cases and to have like a trucking lawyer. But if you had $1 million policy with 2 surgeries, I mean, I think the case could be worth the full $1 million. I don't know what type of surgery, but if they're anything like fusion or even arthroscopic, it could be worth $500,000 or more. So yeah, just text me 347-566-9595. I'm happy to chat and offer you like a free consult. And if you wanted me to help, if I could help still, if it's not too late, I'll be happy to help. And RG says they accepted that they hit me, but they said it's impossible that I got all those injuries. No previous accidents, no medical records. Also, they're saying that it's not from the truck crash, it's from something else. Yeah, that's a typical defense. But, you know, a good trial lawyer should be able to beat that. Basically, you just show a timeline. That's a good way to beat it. You say, look, if it's not anything else, you're just saying that at the exact same time that this huge tractor trailer hit me, I just also started to feel really bad. And you see my medical history, the last like 10 years, I haven't been anywhere. And you actually get a timeline and it just shows all the months, like for like say 10 years. And it's, you know, or all the years, but you know, you do it by like each month or whatever. And you show like 10 years before, there's nothing, no doctor visits. And then the day of the crash, now you start going like a chiropractic, physical therapy, surgery, hospitals, all blah, 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 blah. You're like treating all the time. But you're saying, but that's not caused by the truck crash. It's just a coincidence, right? It's just I mean, it's kind of ridiculous. You can make it really seem, you can make them seem ridiculous. Yeah, so I mean, you're okay with that. And Digital Audit says, would it hurt my case showing up at a Geico deposition eating gecko tacos? No, I don't think so. I'd like to see that. If you do that, send me a video. That's cool. And Baby Boy says, hey, buddy, you rule, but I'm still waiting. I had 2 surgeries, neck fusion, and a hip replacement over a year. I still have no deposition or nothing. Oh, I'm sorry to hear that. Yeah, I mean, 2 surgeries, neck fusion, and a hip replacement. That's pretty serious. That should be worth a lot. But you know, just text me 347-566-9595. I'm happy to do a consult, figure out what's happening. Benito says, have you ever had a case where there were 2 car accidents in one day? One was a fender bender, and the second was a rear end. The second one sent me to the hospital. Yeah, I mean, I have had that happen. Probably the best thing to do is just focus on the one that's more serious and then drop the other one, because you can't be treating for 2 at the same time. It'll be too messy. And then Secreting says, if you are caught on video doing something you said you could not do, when would the defense attorney show you? Do they have to show you at deposition, or could it pop up at trial? I mean, they could show you at trial, but they would have to exchange the video with the lawyer. So the lawyer should call you and show you, your lawyer. They can't just like, hey, I have this video, and then, you know, they have to serve it on the lawyer. Usually, what's what they do? They have to serve it. It's called sub rosa. Yeah, so they have to serve the sub rosa material. So we get that. Usually, they do it after your deposition, because first they want you to say what you can't do. Then they want to catch you doing what you can't do, right? And then they send the video to us, and we get these videos. Like whenever I'm preparing for trial, I get these videos. I'm like, oh, I hope it's not a bad one. You watch the videos, and but yeah, the last few that I've gotten were not bad at all. Well, the last case we did, they didn't get a video at all because the guy didn't really do anything. They tried to get a video. What they tried to do is really funny. The guy lived in the Bronx, and so they go outside his house and they put a big, you know, what are these, like cat litters, like the really big ones? I don't know, what do they weigh, like 20 pounds? And they put it like in front of his tire where his car is parked. So they're thinking he's going to bend down and he's going to like pull the cat litter out because he has to go somewhere and he's going to drive. And they're going to videotape him doing that. But he was smart. He saw the cat litter there. He's like, what's this cat litter doing? And he just didn't touch it. And so they didn't get anything. So they never even served any video. And then the other one was the one where we got 3.5 million for the client who fell down the stairs against the New York City Transit Authority. And they had him, but they had him basically driving his car, but he said I could drive. And they had him getting out of his car and then going around and like pressing the button, and then the trunk opens and he took a piece of paper and there's nothing. Like, it was like, okay, show this video. And then we took a deposition of the videographer, and he was like some kid that, just graduated, and he was, I don't know, driving like his dad's Mercedes, trying to, make a buck. I think he got paid like $2,000-$3,000 to shoot these videos. It was like, I don't know. I think the jury would be more mad at them because it's such an invasion of privacy. You're following someone around, you're videotaping them. Like, what did you get? And then what about all the outtakes, right? You can't just show the bad stuff, meaning like, oh, here, the person's doing something. You have to show the whole video. You can't they can't cut everything else out. Because if you say, for example, there was a case I was watching on CBN, which is the Courtroom View Network, and they also had video of the injured lady, but there were parts where the injured lady was walking and she was like wobbling. She wasn't walking the way a healthy person walks because she's injured. She had fusion. So they're like, why didn't you show that? You have to show everything. You have to, if you're going to do the video, then be real, be independent, be true. You can't like cut, only what's good for you for the defense, and then remove everything else, which is what they do. So you have to be really careful with that. Okay. And Benito says, how can I look up if my lawyer filed a lawsuit? Well, I mean, if it's a lawsuit, you would know. It'd be public in the courts. You could look up on the court's website. Like in New York, we have NICIF or E-Law. If you're in another state, you could ask, or just ask the lawyer. I mean, he should tell you, of course. And then Allure says, how much would most clients receive after a settlement? I was told 1/3. No, the clients would receive like 2/3, right? Because the lawyer takes 1/3. So if it's like $1 million, the lawyer takes, let's say, $300,000. The client should get $700,000. Now, of course, there's some expenses that might come off the top, but usually those are relatively small. The only time the expenses get big is if you go to trial, right? Because if you go to trial, you're going to have to start paying the doctors, and the doctors have to like cancel all their surgeries and come to court and testify for you. So they might say, hey, I want $5,000, I want $10,000. So then you could start getting into higher expenses because you pay that doctor 10, that one wants 15, this one wants 7,500. Now you spent like 30, 40,000, right? But otherwise, it's not usually that much. And then Mule Boy says, you mentioned that you received $400 to $850 for a slip and fall with shoulder injury and anchors. You also mentioned that the reason was because the tread on the step slipped off, creating the fall. Can you talk about the strength of the case that helped you receive the type of an award settlement other than the severity of the injury? Oh yeah, that case. I don't really remember it so great because it was a few years ago, but I could maybe pull the file and do a video about it if you're interested in that case. It was, I think I remember, it was like a guy in Brooklyn. He was basically going somewhere with like other people in his family, and he might have been like in the middle. So some people went down the steps. It was an apartment building, one of those like six stories, 6 floors, one of those red brick apartment buildings that we have in New York City. This was in Brooklyn. And then as he stepped, I think the tread, came off. I forget now if it was like concrete or if it might have been rubber. It just kind of like a padding, like a rubber padding where you put your foot, the horizontal part, it just kind of like flew off. It was just broken. I think he had even complained about it before. And he fell all the way down the stairs. And then he ended up having a shoulder surgery, and it just involved anchors. So it was more than just a scope, and it didn't heal that well. And I'm pretty sure, that one, I think we got $850 for that one. But some of them you get like a little less. If it's just a scope, it might be even like $200, $300. It could be like $400. Usually the more severe the injury is and the impact you show on someone's life, then the higher the amount will be. But yeah, that one, we just settled. I think it was on the trial calendar, and we settled it on the trial calendar. But I could pull that file and maybe do a video about it. I don't know if I've ever done a video about that one because it wasn't really prepped for trial. It was more of a settlement. So But I remember the client. He was a nice guy. And Digital says, I think ex-insurance company defense lawyers are planted by the insurance industry to lowball your claim. Yeah, I mean, it's true. They really do like to lowball. And Brandy says, what happens if a truck driver rear ends me and he gets a ticket and doesn't show up to court? Can that go against him when we go to trial? I mean, I'm not sure if that's going to be admissible if he gets a ticket, depending on what the ticket is for. If the ticket is for, rear-ending you or following too closely, if it's admissible, you could try and say, look, he was found guilty because he didn't show up or whatever. So there's like that finding, but I don't believe that. I don't know if that's res judicata, meaning I don't think you could take the finding of him not showing up in a traffic court and then use it to prove negligence in a personal injury case, because they're two different courts. You probably have to still prove, but it's easy to prove, right? He rear-ended you. You didn't do anything wrong. You're stopped. So you probably get summary judgment on that. Just file a motion and you'll get a judgment and then you're done. Because how can he say, unless he comes up with a non-negligent explanation, like if he says, hey, I was driving and I was careful and I was, 2-3 car lengths between, the front of my car and the rear of the other car, and all of a sudden she slammed on her brakes and I couldn't stop, right? If he says something like that, then maybe the judge won't give summary judgment. But if he doesn't have an explanation, then you're going to get summary judgment. So it's a pretty slam dunk case. And Marquita says, my lawyer said Publix is not going to read my demand letter I prepared because it's too long, but it details my injuries and damages extremely well. I mean, I don't know. It's hard for me to say. If it's 50 pages, maybe it's too long, but you could usually when I write them, they're like 15 pages, 12 pages. You don't have to put everything in there. What you have to put is all the medical diagnosis, a little bit about how it affected you and your life, like a little bit of the human story and the liability as well. But yeah, I mean, it just depends. If the lawyers, like I said, if it's a real trial lawyer and they're sending that letter and they believe they can get more at trial, then they'll position it in a way where they'll say, hey, pay me $1 million now. You have 30 days. If you don't, that's fine, but it's not going to be, that's your only chance to pay the $1 million. After the deadline expires, like say he's sending a letter today, so he'll say, hey, 30 days, February 22nd, let's say. But on February 22nd, it's going to be $3 million, and that really puts the pressure on them. Either, pay less now or pay more later, but you have to really stick to your guns. You can't bluff, because then they'll know, hey, this guy's bluffing, and then they're not going to pay anything. And Robin says, what happens at a pretrial conference? So usually just, it's a pre-trial, so they could try to settle the case. They could talk about any issues, talk about scheduling the trial date, when is a good time for the trial date, and then you'll get the trial date usually at the pre-trial conference. Depends also like what court, right? Some courts, like federal court, they might want a pre-trial order with actually, you put in like who the witnesses will be, so a little bit more involved. State court, they usually don't do that. And Secreting says, thanks. Oh, you're very welcome. And Faces says, have you ever lose in any trial? Recently I haven't. I have lost some trials, like back when I first started, back in like 2001, 2000, when I first became a lawyer. I did, lose a few trials. Everyone's going to lose some trials. If anyone says they never lost a trial, they're lying. But that's part of it, right? Part of it is stepping into the arena and taking a chance and being fearless and going for it. But when I was very young, I took some tough cases. Like I remember I took one case where it was a medical malpractice, and I was representing this like 90-year-old grandmother, and she said she went to the chiropractor and he was just doing like a massage, but he pushed too hard and one of her ribs broke. And we tried the case, and it was like a 2 or 3 week trial, and it got really like technical, and we had all these like medical points, and I thought, and the judge actually said he thought we were going to win. He was going to vote for us, but the jury didn't like the case. I think they didn't believe her that it really happened, or it's hard to say, and we lost. But yeah, everyone's going to lose. Like I said, everyone's going to lose some cases. Okay, and then JP says, how much is an ablation case worth? Yeah, so an ablation, by itself, if it's just an ablation, it could be, it's hard to say. It could be like 50, 100,000. If it's an ablation, usually an ablation is with something else. Like it'll be like a discectomy with an ablation or an epidural with an ablation, and those could be also like could be into the six figures, I would say, like low six figures, based on the pain and suffering. And then Payne says, is it possible for the defense to intentionally get their answer stricken, allowing the plaintiff to win on default, delay discovery due to overwhelming evidence against them that could further damage them? Defense ignore court orders and motion to compel. I mean, I don't know. Why would they want to get their answer stricken? If they get their answer stricken, then they're not in the case anymore, right? Then it becomes a damages only case. So then your lawyer just shows up and explains your damages and then gets you a big amount and then they have to pay it. So why would they want to do that? I don't think that's intentional. But it does happen where a judge might strike their answer, but usually it's if they just never produce their client for a deposition, or they just, violate orders over and over again. So it might be a combination of, let's say, it could be a combination of them just being like lazy or slow or not following the judge's rules, or it could also be, it could also be that their client is not cooperating. So the lawyer might be like, hey, give me this information, following up, calling, email, but the client's just not cooperating. That happens. And then there's just nothing they can do. Okay. Somebody said, can you put the phone number? Yeah, you could text me. I'll drop it in the chat. And then Chill Baby says, how long after the deposition does it take to settle? So after the deposition, I mean, you could settle at any time. You could settle before the deposition. So it's not really any time after that it takes to settle. It's just whenever they're going to pay, right? Whenever you start settlement discussions, you send a settlement letter or you pick up the phone and call them, your lawyer, I mean, and whenever they make you an offer that you're happy with. So it could be at any time, but usually, I would say usually after the deposition, maybe a few months later, maybe after the IME is a good time, or when you're on the trial calendar, when you're waiting for the trial, because at that point, everything's done. And Alex says, a judge was recently assigned to my case in Brooklyn. How can I find out if she is a good judge? Well, I mean, if a judge just gets assigned to a case and it's just a new case, it doesn't really matter if it's a good or bad, because it's, there's not really such a thing as good or bad. It's really, they're just overseeing the case, they're not going to be the trial judge, right? The trial judge will be picked later from the JCP. When you get sent out to pick a jury, they're just going to randomly assign one of the judges to you. It probably won't be the same judge. So this is just a judge who's going to oversee discovery, compliance conferences, just make sure, discovery gets complied with, things like that. I mean, the only way they could be really good or bad is if they're going to be deciding some motion, and then the motion they're going to be deciding, if they're tend to be more insurance friendly, they could deny your motion, or, I mean, you could look up, there's certain websites, I think there's one called Robing Room, where lawyers give ratings of judges, but I don't really know if it's going to be helpful, it might not be on the same issue that you need. It might be about something else. Like a lawyer could be talking about, hey, I had a bad experience in a criminal case or in a divorce case, and you have a personal injury case. So it's just, but you could take a look at Robing Room or just Google the judge and find out a little bit about them. And Chill says, 5 million policy, back surgery, lumbar disc, how much is it worth? So a 5 million policy with a back surgery, if it's a fusion, it could be worth significant. It could be even the full 5 million or close, like 2 or 3 million, depending on where it is, depending on the liability. It could be significant. I mean, usually fusion cases are significant. Like the last few I did, right? We had 2.8, 2.5, 2.2, then we had 3.5. So something like that, I would say. I mean, sometimes a little less, it could be 1.7, 1.5. Each case is going to have its own settlement, its own verdict value. And Burnt says, explain 100K policy and 1 million umbrella. So yeah, so 100K, that's just 100,000. That's the policy that they have. A million umbrella means they have after the primary, whatever the primary is. Let's say the primary is 250, so you have 250, and then after that you have another million umbrella or excess insurance. Usually you don't have like a 100K policy with a million umbrella. Usually to get a million umbrella, you'll need at least 250, 300 could be a million umbrella, 500 could be a million umbrella. I don't really think they have too many with, I mean, it's possible, I guess, but I think one time I was speaking to an adjuster and he actually said, this is a long time ago too, but he said, it's not possible. You can't. If you have a 100,000 policy, you cannot get a million umbrella. It's just not. That's not how the insurance world works, basically. And then Lakeisha says, can I text the number because I need a new lawyer? Yeah, sure. Text me 347. 347-566-9595. I'm happy to do a consult. Maybe tomorrow or Thursday I'm available. We could chat. Mule Boy says, don't forget to press the like button. Yeah, absolutely. Thank you. Yeah, press the like button, like and subscribe to our channel. Let us know what questions you have. Let us know what videos you want to see. We could do some more videos in the future about some topics. I've been doing some about verdicts, about other topics, but I try to, keep it interesting and keep the channel strong. Leonardo says, hello. Hi, how are you? Chill says, oh, that's the question we answered at the 5 million policy. Preacher says, before you send the settlement opportunity letter, does your case mostly trial ready or do you get trial ready after filing? It doesn't have to be trial ready to send a settlement opportunity letter. You just have to kind of know what the case is about, right? So you have to know what the liability is, meaning like what happened, who's at fault, and what the damages are. The client maybe already had their surgeries. They're not going to have any more surgeries. They could still be treating, like seeing their physical therapy or following up with their surgeon 2-3 times a year. That's fine. But you have to already know what the case is, basically. And then you could send a letter and say, hey, I think this is worth X, pay me, or else we go to trial. It could be more. And Digital Audit says, can you demand to speak directly to the insurance adjuster and bypass Sedgwick? Ain't nobody got time for a middleman. Sedgwick is Sedgwick. Oh, Sedgwick is Sedgwack. Yeah, I mean, you could try, or your lawyer could try, although sometimes, they're a third-party administrator. So it could be that the insurance company uses them to administrate the whole claim. And so the insurance company gives them authority, and then the insurance company just doesn't get involved with claims at all. So then there's not really anybody to speak with. So you might have to speak with Sedgwick, but maybe one of the, higher ups at Sedgwick, one of the supervisors, and then get it settled. But if the insurance company also has an adjuster that can offer money in addition to, or aside from Sedgwick, then you could speak to them as well. It just depends on how they have it set up. But I know Sedgwick is usually a TPA, which is a third-party administrator. And then let's see. DB says, I have a construction injury third-party lawsuit. My attorney is planning to file for summary judgment. How long does the defendant have to respond to the motion? Yeah, so it depends on where it is. Like in New York, usually they'll have 30 or 60 days. If they ask for an adjournment, they can have a little more time. Depends on where too, like Manhattan or Bronx might be a little bit more time. Brooklyn can get time. Just depends. But yeah, usually something like that, like they'll have 30, 60 days usually to respond, and then you wait another month or two for the judge to give you the decision and the order. Reginald says 2/3, but doctor's liens must be paid from that as well. Yeah, I mean, if the doctor has a lien, like in New York, we do it differently, right? Because the doctors get paid by the no fault. So there's 50,000 automatically that can go for medical care. So usually the doctors get paid. So sometimes there are no liens. But if there's a lien, meaning somebody signed and said, hey, I want free treatment now, but then later at the end of the case, I'm going to pay you for this treatment, that's a lien, or also known as a letter of protection. I'm going to protect you, protect your right to medical services, right? Then you have to pay them. Okay, let's see what other questions we have. Lost in Awareness says, I had a knee arthroscopy and have recommended hip arthroscopy, but doing pain management for the hip and had 3 injections already. What's that worth? So knee arthroscopy and a hip arthroscopy, but you're not doing the hip, you're doing the injections. I mean, a knee arthroscopy and a hip injections, it could be worth, you know, $200,000-300,000. It could be worth a little more. It's hard to say because it depends on everything, right? It depends on liability, where you are, what venue. It depends on the overall impact to your life, how everything has changed, whether you have like before and after witnesses. Depends on the lawyer who's handling it, if they're a real trial lawyer, if they're prepping it the right way. So it's kind of like the whole picture. You can't just say, hey, I have this injury, what's that worth, right? Because it's just like, I mean, you could take a guess, but I don't know if the guess is really going to be helpful. Like you could say, I had an L5-S1 herniation, what's that worth? Well, yeah, in Alabama, maybe it's worth $10K, but in like Chicago, it could be worth $250, and in New York, it could be worth, you know, $500. But it doesn't, or it could be like you have this injury, like an L5-S1 herniation, but with one person, they could talk about how it impacted their life, how it changed everything, and then a jury really would, you know, like them and understand and give them $1 million, right? And someone else, the jury might say, you know what, I don't even believe you have this herniation from this crash. It might just be you had this before. You seem like a shyster and give you nothing, right? So it's not an exact science. But yeah, there are certain estimates you could make. Okay, and then Chill Baby is talking about a $5 million policy, back surgery. We did that one, right? Back surgery. Depends on the type of back surgery, I think. But yeah, it could be, definitely. If it's a fusion, it could be into the millions. I don't want to say it's going to be 5. It could be 1. It could be 2. It could be 3. It could be 5, but you know, you'd have to really work it up to get a larger amount. Reginald says, chill, baby. He sees your questions. Chill. Chill, baby has to chill. Okay, let me see. Go back up. Make sure I didn't skip over any questions. No, I think it's good. Oh, Truth Seeker says, what are the next steps after filing a lawsuit? So you're going to do discovery, which is like document discovery, meaning asking for documents and also responding to documents. So as a plaintiff, the response to documents would be giving them medical records mostly and asking for documents depending on type of case. If it's a car crash, you would ask for property damage estimates, photos. You would ask for maybe go to the scene, take photos there, or if they have pictures, things like that, the police report, right? If it's a slip and fall or a premises case, you would ask for maintenance records, inspection records, whatever you feel is relevant. So you can ask for documents, and then also you'll have depositions where they ask you questions, you answer, and then you ask, your lawyer asks them questions, the defendants, and they answer. And then Jose says, do most of rear-end cases go to trial? No, I think most settle. Most cases in general settle. Very few cases go to trial. Usually, I think more than 95% of cases settle. The cases that go to trial are going to be the cases where there's really some kind of issue which requires a trial, right? Because if the parties could agree, they'll try to settle. And Felipe says 4 million policy, back discectomy and neck discectomy, right knee ACL scope in the Bronx. Okay, so you have a back and a neck discectomy and a right knee ACL scope, and you're in the Bronx. Yeah, that could be a nice case, depending on how it happened and if you have the liability. That could be worth into the millions. Yeah, ACL scope is pretty serious, and discectomy also is serious. So that could be. And Chill Baby says it's not a fusion, but it's a lumbar, probably deceptive. Probably you mean discectomy also. Yeah, well, that could be worth it. I had a lumbar discectomy case a long time ago. I think we got 1.6, 1.7, and it was without a fusion. So that it could be significant as well. And Sandy says, hey, what's up? Just checking up. Hope everything is well. Well, great to see you. Thank you. Yeah, everything is good. Marquita says, can claims worth $1 million or more settle, or are they more likely to go to trial? They can. Yeah, they can. Like most of the cases do settle. I mean, even this case I was talking about, right, what I read about in the listserv, it was like 125 million and it was a settlement. But, you know, a lot of the time they settle for $1 million, they settle for $2 million, they settle for $5 million. If it's labor law, like with the construction workers, sometimes I see even higher settlements, like 15 million, 10 million, you know, it happens. So, but of course, that's one of the factors, right? If you're asking for a really big amount and you could only have that amount, and if they're not willing to pay that amount, then that's one of the reasons why it might go to trial. And then Reginald says, can you explain self-insured retention policies? Company said they have 1 million with 5 umbrella coverage. And then when we sued them, they said they are self-insured retention company, no insurance. Oh yeah, so self-insured retention usually means that they're self-insured up to a certain amount. So maybe the first like million could be self-insured, meaning like, you know, they have to pay it, or they're self-insured up to that. And then if it's more than that, then you get into policy, other policies. So it's kind of similar to having a primary and then having an excess. So they're self-insured maybe up to $1 million, but then the next 5 million will be like a policy with whoever, Chubb or, you know, whatever company. So that's a good sign usually, because it means they have a lot of insurance. Usually big companies have it. And Felipe says, sideswipe accidents hard to deal with. No, not really. I mean, as long as there's proof of liability on the defendant, you know, as long as you're not the one sideswiping others, you know, if you're just driving and someone sideswipes you, changes lanes, and then doesn't see you in the lane and hits you, they're at fault. Those are pretty clear-cut cases, and there's some serious property damage, and the doctors will say that, hey, this type of impact is consistent with the injuries that you sustained, you're good, as long as you have that. And then Devin says, have you ever done any cases versus Western National Insurance, Oregon State is where the driver of the semi is from? No, I haven't done that, you know, cases with them. I don't remember. It sounds familiar. I know there used to be a Republic Western or something like that. I don't know if that's the same. Western National. There's a lot of insurance companies. I mean, they're all pretty much the same. Some of them are just like more likely to, hey, pick up the phone and talk with you and offer you money. Some of them are more, hey, like, we want to make us pay, go to court and make us pay. But it doesn't mean you can't do it. A trial lawyer can still make them pay. It's just how willing they are to just settle. That's usually the only difference. But I wouldn't say like one is better than another. Remember, you're not really fighting with the insurance companies. You're fighting with the lawyers. So it really depends on the lawyers that they hire to defend themselves. And then Devin also says, how would liens be lowered? Yeah, so you just call up the providers and you just speak with them at the end of the case and you try to lower them. So for example, if the case settles for a small amount, right? Let's say it settles for 100,000 and you have all these liens. Well, you know, you're going to want the lion's share because you're the client. So then the doctors have to take less. It's like kind of like you have a little pie and you have to divide the pie up between whatever it is, 5 people, 10 people, everyone gets their little piece. But if they're asking for like $100,000 lien for medical treatment, well, they can't take it, right? Because the whole client share maybe is 70 because the whole thing sells for 100. So then they have to take, you know, if the client's getting 70, maybe they have to take like 10 or 15, you know, so the client still gets most of the money. So you just try to negotiate it like that. And then C. Hampton says, hello, I had a slip and fall. Slip and fall outdoors, severe wind storm appeared out of nowhere, 2 broken vertebrae, concussion, and damaged both elbows. Workers' comp stopped treating, waiting on a hearing. Oh, I'm sorry to hear that. Yeah, that could be. I mean, you know, I don't know. I don't know if you could sue if it's a windstorm, depending on like what caused you to fall. If it's just, you know, the weather, that could be unavoidable, right? It could be a workers' comp only case. And then 144 says, how long is the MVA arbitration process? How long before they give you a hearing? The motor vehicle arbitration. Usually it's just a few months. I mean, they could ask for some discovery before they agree to the actual arbitration. So if that's the case, then it could be a little longer. But if the lawyer complies with all the discovery, it shouldn't be too long. And Buckshot says, if the at-fault insurance company accepts 100% liability, is there still a possibility that they might negotiate in bad faith and thereby prolong the case? Yeah, of course, because remember, when they're accepting liability, they're only accepting liability, meaning that they were at fault for the crash, the incident, right? They could be at fault for the crash, and then they could say, yeah, we're at fault for the crash, but guess what? The crash didn't cause any injury. You had all these injuries from living your life. It's the normal, painless aging process. It's degenerative changes. This isn't from this little crash that we had, right? So then we pay you zero. That's known as causation, right? You have to prove that your injuries were caused by the crash. So whether they take responsibility for the crash or they don't doesn't really matter, right? They could say, yeah, we take responsibility. In fact, I was talking about that earlier in this live. They love to do that, right? Because they want to show, hey, we're the good guys. Look, we're being honest. We take responsibility. We're to blame. You know, we call it like we see it. You know, and then they use that to then pay you less money because they're going to say, but guess what? It wasn't caused by this crash. So it actually, a guy wrote a book about this. I think one of the defense lawyers, and he was saying that's one of the ways to reduce the verdict. Take responsibility, you know, for something. Obviously, don't say we're completely at fault or we caused this, but take responsibility for some little thing, and then use that to then, you know, anchor the numbers lower. So it's a trick they play. But yeah, you still have to prove that they were, you know, that they caused the injury and that the injury is serious, and you have the injury, that the injury is from the incident. That's still something you have to prove. Okay, and then the machine says, hi, Arkady, best in educational channel for personal injury in the country. Thank you, Mr. Arkady. Oh, you're very welcome, very welcome. And Gary says, how much is my case worth with 2 years of physical therapy, shoulder surgery, $1 million policy? Yeah, I mean, I'd have to know a little more, you know. I know everybody wants to know what their case is worth, but I don't want to start like shooting numbers based on like comments because, you know, there's just so many factors, right? Like I was saying before, it depends on the plaintiff, it depends on the venue, it depends on the lawyer, it depends on so many factors. But I think like with shoulder surgery, I usually see like 150, 200, 300, it could be more. Like we had that one for 850, right? That was a shoulder surgery. Depends on the surgery. But yeah, usually there's not like a one size fits all kind of answer. And then Mule Boy says, thank you for sharing your knowledge. Oh, you're very welcome. Yeah, absolutely. Okay, that sounds good. I think we got to all the questions. Yeah, if anyone else has any questions, feel free to drop it in the chat. If not, then please like and subscribe to our channel. Let us know what questions you have. Let us know what videos you want to see, and we'll do some videos for you. We are happy to help. That's what it's all about. We're here to help serious injury victims and families. Yeah, that's what it's all about. We're here to help. And I'll leave my number in the chat. Okay, everyone, have a great night. Thank you for being here. And we will do another one maybe later on this week or next week. And then I'll do a few more videos where we answer questions and we talk about interesting topics. Okay, have a great night. Bye-bye.